The Law Report with Karen Key.
And a very good evening to you from tonight's Law Report programme. Well, this evening we're focusing on sectional title and homeowners associations. And just to explain a little bit about both, let's begin with sectional title. And sectional title came about to allow a person to purchase a section of a building or property, such as a flat or an apartment in a larger block. A managing agent is usually appointed to manage the common property on behalf of the body corporate. The body corporate is the collective name given to all the owners of units in a scheme. And the question of ownership of non-sections or common property, such as stairwells, walkways, passages, refuse rooms, and all those sort of things, well, these are owned by the collective owners of the flats or apartments in undivided shares. Sectional title is currently governed by the Sectional Titles Act 95 of 1986, which sets out the requirements, functions and duties of the body corporate. The new Sectional Titles Schemes Management Act No. 8 of 2011 has been approved by Parliament and signed by the President. It is, however, not yet in operation. Well, a homeowners association, on the other hand, is an organisation which represents a body of owners in communal living. A legal entity is needed to act and do business on behalf of owners, and in some instances, a Section 21 company, which is a company not for gain, is used, but the vast majority of these associations are formed under Section 29 of the Land Use Planning Ordinance. Well, if that's all starting to sound just a little confusing, my guest tonight will make it all a lot clearer. He's Phil Colothy, owner and managing director of Land and Sea Development Services, and is a specialist in the corporate management of sectional title schemes and private estates. He provides guidance and advice to trustees and directors of those corporate bodies to assist them in properly exercising their corporate governance responsibilities on behalf of their members. And for the last 15 years, he has been in the field of developing and managing sectional title schemes, private residential estates and residential share block schemes. Phil, good evening. Welcome to the show.
Evening, Karen, and to the listeners.
Well, you tune to SAFM, South Africa's news and information leader. I'm Karen Key, and this is the Law Report. My guest tonight is Phil Colothy, owner and managing director of Land and Sea Development Services, and is a specialist in the corporate management of sectional title schemes and private estates. If you have any questions for us, you can call us on 0892 10 2010, 0892 10 2010. Phil, now there are lots of questions around sectional title and homeowners associations, and as I said, it all starts to become a little murky when you start trying to figure it out. If you're not quite sure what's going on, there's a lot of things that we need to understand. Now, whose responsibility, firstly, is in practice, is it to apply the requirements of the Sectional Titles Act?
The trustees of sectional title schemes have the prime responsibility. Each sectional title scheme is a business in its own right, and the members, the shareholders of the business, are the members who own sections in that scheme. In the same vein, with the Homeowners Association, the people who own plots are the members of the business, and they elect trustees to look after their business. And so it's the business, the prime responsibility is with the trustees. And generally speaking, trustees then hire a managing agent to do the work and pay the managing agent to actually affect their responsibilities, but they still remain the responsible parties.
Okay, we'll get to the managing agents again in a moment, but let's move on to homeowners associations. What law governs the corporate management of homeowners associations?
It depends. There are different types. A homeowners association can either be a Section 21 company, or else it could have been incorporated as a Section 21 company, or else it could have been incorporated under Section 29 of the Land Use Planning Ordinance, which is generally speaking the preferred option. And both of them, in fact, with the Land Use Planning Ordinance, the document is the constitution of the association, and the constitution is something that's generally put together by the developer and approved by the local authority. That is, in fact, the law in those instances. When it comes to a homeowners association, that's a sectional titles, that's a Section 21 company. There, the Companies Act applies, but then again, each association will have its own articles of association which determine how it must be managed.
In the case of both sectional title and homeowners associations, that constitution is what I suppose governs how things work. And if you're going to buy into either one of those developments or situations, you have to then abide by the constitution.
That's correct. And it's absolutely essential before you're buying into one of those, that you establish that there is a constitution, because it's not unheard of that homeowners associations are not in existence when plots get sold, and it's sort of been left behind by the developer. Can happen.
There are certain things that people should look out for when they buy into an existing either sectional title or a homeowners association situation. I mean, I think, for example, in the sectional title thing, you need to see what the books look like, whether the block of flats you're buying into possibly is in dire financial straits. You're going to be in for a lot of money if you don't look at it before you actually start.
That's the most important thing to look at, and in particular the balance sheet. You've got to see, are there reserves? Because if there aren't any reserves, you must be very careful. You might end up paying a special levy very early in your occupation of the unit you've just bought to pay for all the effort of the previous owners in maybe mismanaging the place. So it's very important that the balance sheet is a good balance sheet with a good reserve.
And I suppose also in both cases, in sectional title, you have to look at the maintenance of block. If the block of flats is literally falling down, the paint is peeling, the windows are cracking, you need to look at that, because sooner or later, imminently, there's going to be a special levy. Or possibly there isn't going to be one, and the block's going to keep looking dilapidated and run down. And in a homeowner situation, I think then you're in for things like roads and all that kind of infrastructure that you wouldn't have in a sectional title development. But that also has to be in good working order before you buy, or make sure it's about to be fixed and you're not going to be landed with a huge bill.
Yeah, 100%. You do yourself a favour by looking at the building carefully, asking lots of questions. Is there a maintenance contract for the lift? That sort of thing. Just make sure everything is above board and looking good.
And what are the main causes of corporate governance problems in residential complexes?
I would say the main problem would be ignorance. When people generally, the sad thing is owners get upset, and that must be avoided at all costs. And they generally get upset because maybe they don't know what their rights are. They might assume their rights are more than what they really are. And secondly, the trustees themselves might not know what their obligations are. And it's terribly important for trustees to know, in the case of sectional title schemes, to know the Act, know what their responsibilities are, know how to implement their responsibilities. And it's very, very important that the members actually understand what to expect of the trustees and understand what are their responsibilities too. That it's not all the responsibility of the trustees.
Now, we mentioned managing agents. Now, is there a regulatory body that oversees managing agents?
Yes, managing agents are defined as being estate agents in South Africa, and there is no managing agent regulatory council, but because they're called estate agents, they are governed by the Estate Agent Affairs Board. So as far as consumers are concerned, that's the body they have to go to. If their trustees can't do anything about the managing agent, if they want to seek relief, they must approach the Estate Agents Affairs Board.
We have had calls on one of our property shows in the past where people have phoned in having problems with the body corporate being in collusion with the managing agents, and things are not all that much above board. What sort of recourse do the other owners in the block have?
Well, it's a difficult thing to prove that the trustees are in cahoots with the managing agent. You know, it's all a question of applying proper corporate governance. If there's a rumor of that, then you must tackle the trustees head on. Call a general meeting and question the trustees. If they aren't, I mean, what does cahoots mean? Cahoots might mean that they're keeping a managing agent who's inefficient and by rights should not be there anymore.
That pretty much, I think, was where they were going with it, yes.
Yeah, and if that's the case, they can do something about it. They must call the trustees to task and tackle them head on at a general meeting.
Just talk to me a little bit about these general meetings now, because you have this group of people who are the sort of, what would you call them? They're all trustees.
The elected trustees.
Okay.
Yes,
And you have the owners, the rest of the owners. Now, you have to be elected to be a trustee.
that's correct.
Okay, and you then become almost like a governing body of that block, the body corporate.
Yeah,
but the body corporate is everybody in the block.
That's right. The body corporate elect the trustees,
Okay.
i.e. the shareholders or the body corporate. And they elect the trustees, and the trustees basically have to work for them and have to make sure they don't look after their own interests. The job of the trustees is to look after the common property for the collective benefit of all the members. And they've got to always have that in the back of their minds, that they can't have favoritism towards a particular member or whatever. Their decisions have got to be in the collective interest of everybody.
I'm going to talk to you about common property in a moment, but just to remind people that you tune to SAFM, South Africa's news and information leader. I'm Karen Key, and this is the Law Report. My guest tonight is Phil Kolothi, and he's owner and managing director of Land and Sea Development Services, and he's a specialist in the corporate management of sectional title schemes and private estates. If you have any questions for us, you can call us on 0892 10 2010, 0892 10 2010. Let's talk about common property. I mentioned a little bit about that in the beginning, and that's all the things that aren't actually the flat or the apartment itself. It's everything else.
Yeah, it's everything that all the members get a benefit from. So, I mean, in a sectional title scheme, the owner is responsible for his section, his or her section. Now,
which could be the flat and the garage, for example, whatever you own yourself.
Or whatever you have an exclusive right of use over as well.
Let's talk about exclusive rights.
So you have to look after your section and your exclusive use area. It is actually not the responsibility of the board of the body corporate to look after your exclusive use area.
What would fall into exclusive use areas?
Well, your balcony could be an exclusive use area. Your parking bay could be an exclusive use area, which is an interesting one, because generally speaking, the body corporate tends to look after all the parking areas, but by definition, the owner is responsible to look after his exclusive use area.
Wouldn't that be something that he owns? Because normally people pay for that parking area, that parking bay, or are you talking about just general open parking?
No, I'm not. I'm talking about a specific parking bay, a bay for his exclusive use.
Okay, but he would have paid for that, surely.
Not necessarily. Some developers like to make the owners pay.
Oh, okay. I thought it was a given.
You either pay for it within the price of your unit, or some developers, to make the unit sound cheaper, have a lower price for the unit and just add it on for the parking bay.
Okay, all right. So that could be exclusive use. Okay.
It is different. It is definitely an exclusive use area, and it might not only be an exclusive use area. In some instances, it gets forgotten, and then rules. It has to be, in fact, incorporated in the management rules to allocate a bay to an owner. It does happen that it's not an exclusive use area, in fact. Okay,
some blocks will have a swimming pool, for example, or the refuse room, or whatever it is, and that all has to be maintained by the body corporate.
That's common property, yeah. Okay. Trustees are responsible for that.
Okay, so you don't have to worry about any of that. That would be part of the levy. Now, let's talk about levies, because that's the one thing I think that sometimes people forget when they buy a property in a sectional title. There's always going to be this levy, a monthly levy.
Correct.
And what is that supposed to cover?
Now, that's an interesting question, because levies are supposed to cover the trustee's estimate of expenditure for the following year, not a percentage increase on the previous year, which some trustees tend to do. You are not allowed to do that. That's actually contrary to the Act. The trustees have to go through every item of expenditure when they do their budget, before they do their levy, and estimate what the expenditure is going to be in each and every cost item that they have, and determine their expenditure for the year that way and apportion it according to the participation quota.
Now, that could also include putting some money away for big cost items that they might have to do maintenance wise.
Yes, you've got to make provision for maintenance. Now, provision for maintenance is it's very difficult. You don't know what's going to happen during the year. So some things you do know is going to happen, like you're going to have to repaint a building every 5 years or something. So you must include an item, a sinking fund, to be able to repaint the building in 5 years' time. If that's not in the budget, you're being rather irregular, because some poor owner down the track is going to just buy in and all of a sudden get hit by a special levy to repaint the building, because the trustees haven't been making provision over all the years, over say 5 years prior, subsequent to the last repainting of the building. So it's absolutely essential that trustees do their estimating, and they don't just take the last year's levy and thumbsuck, oh well, we can the members will accept a 10% increase, so let's give them a 10% increase.
So it has to be an increase for a reason, not just because it's 10% and it's a new financial year.
Precisely.
Is there a levy for exclusive use areas, or does that fall under your original levy that you're doing for your property anyway? Or do you have to pay, is it dependent on how much, if you own your unit and a garage, for example, you're paying a levy, but now you also have exclusive use of something else. Would that be an additional levy onto that?
No, because for the reason that I mentioned to you just now, the participation quota is based on the area of the section of what you own. Exclusive use area doesn't come into the participation quota calculation, and that's why you have to look after it. The owner has to look after the exclusive use area, and that sometimes is not applied, but that is a fact.
So if people are wanting to query anything like this, they can go and look at the Constitution, first of all. They have the right to look at the financial status of their unit, of the block that they're in. This is all their right. They have a right to look at these things.
Yes, what in the Sectional Titles Act, they wouldn't look at the Constitution. They would look at the management rules.
Okay.
And they would look at the conduct rules, and they should look at the Act. They should not know the Act, but the Act is the main protection mechanism. But the things that are specific to that particular body corporate will be either specific items in the management rules, because there's a basic set of prescribed set of management rules in terms of the Act, but in certain bodies corporate there might be certain things, management things that are different, that and different rules are registered in the deeds office. The management rules get changed and are registered. The conduct rules also, there's a very basic set of conduct rules in the Act, but because of specific conditions in the sectional title scheme, there can be determined you can add to those rules and have extra rules.
And all these rules apply to both the owner and to the person that they possibly are leasing the flat to. If they have a tenant in the flat, the tenant has to abide by the same rules as if they were the owner.
Most definitely. And the owner is always responsible, not the tenant.
The owner is responsible for informing the tenant and for the behaviour or conduct of the tenant in his unit.
Yeah.
Well, let's go to the lines now. We have Linda in Pretoria. Linda, good evening.
Good evening.
How can we help you this evening?
I think he's answered my question partially, but let me explain to you. We are 6 owners in a block of flats. Each of the flats have their own garage down on a lower level, and then behind the garage it's possible to park a second car without being in anybody's way. Except for one of the flats, that owner doesn't have the ability to park behind his garage. Now, he is very unhappy about that, and he reckons if he can't park inside, then nobody can park behind their garages. How do we handle that?
Phil?
Oh, it's an interesting one. In the management, these parking bays, if the owner has only a right to one parking bay, he has a right to one parking bay. If there's extra space for visitors or whatever, the trustees must determine a method of use of those spare parking bays. There are no specific rights attached to them. The owner only has rights to the parking bay that is his exclusive use area or that has been allocated to him in terms of management rules.
These parking bays have been allocated to, but it's just common. It's common that you would park behind your garage because nobody else can park there. Otherwise, you can't go into your garage.
Your trustees must answer that question. Your trustees must actually manage that situation.
Are there only 6 of you in this block, Linda?
There's only 6 flats and 6 garages, but just the one guy's garage is in such a that he cannot park behind his garage.
So out of the 6...
Out of the 6, yes, just 1 cannot.
Okay, so there's 6 of them. They've all got a garage. 5 of them can park behind their garage. The one of them can't. But now, when he bought this flat, Linda, did he know that he couldn't park there?
Yes, of course he did. Of course he did. It was like that also. And in fact, in an AGM meeting a few years ago, we found evidence of taking a decision that everybody can park behind their garages except for that one flat because it will be in other people's way.
So he knew that when he bought the property?
Yes, he did.
Well, then he's got nothing to quibble about.
He can't then stop the rest of them from parking behind the garage?
Okay. That's what I wanted to know.
No, hang on, Phil, can he
Well,
stop
as long
them?
as they're not preventing him from access to his garage.
Which
Of
you're
course not.
No.
Yes. No, that's exactly how it is, yeah.
Well, then he, according to Phil, doesn't really have much of a leg to stand on. He seemed to know what the story was when he got there, and
Yes.
he can't, because it's almost a case of sour grapes. If he can't, then no one
Yes.
can, you know.
Yes, I mean my flat don't get northern sun, but his do, and I mean I'm not suing him or trying to organise windows in my roof to also get northern sun. That's what I bought. I understand what I bought, and that was the advantages and disadvantages.
Sounds like
Okay,
he's
I'm
jealous.
glad.
He's
Maybe
jealous.
you should get out that original document you said you found at an AGM and just point it out.
Okay.
Good luck
We'll
to you,
do that.
Linda. Thanks for the call.
Thank you very much.
Okay, good night to you. We're off to Ladysmith in KZN. Ishmael, good evening.
Good evening to you.
Hello, how can we help?
I have a little problem with, I must just inquire. We are living in sort of duplex or simplex 5 units. And we do not have a body corporate because each one gets our rates account together, with every month. And we have a gentleman's agreement with everybody that each one will paint his own unit. And, we have common ground, which we also, each one of us worries about the common ground. That's part of his, We don't have any, what what I would want to know is, do we have to have a body corporate?
No, you don't. It sounds like it's a freehold situation. You aren't in one building. I presume you've each got your own urban, in a little sort of, call it a security village, for what do you want, for to coin a phrase.
Yeah.
Now, you don't have to have a body corporate. There is no body corporate. If there's no body corporate registered, you don't have to have one.
I think we had a body corporate originally registered. And then the law changed whereby, each one's rates were coming with his lights account.
They're all getting separate accounts.
Yeah, separate accounts for your rates.
Is it it's not a block of flats or anything, Ishmael?
No.
You're all separate sort of freestanding properties.
Look, if there was no homeowners association, if you bought your plot and your title deed and the seller said you had to be a member of a homeowners association, then you must have a homeowners association. But if a homeowners if these properties weren't zoned collectively as a corporate body to be governed by a homeowners association, you don't have to have one. With so few people, you just live together and in harmony, and just make an arrangement that somebody's just got to look after the front gate if there is a front gate, and each chip in 100.
No, we have an understanding. We don't have that problem with any one of the five units. We don't have any problem with that.
Well, then don't
the only
complicate
issue I
it.
was inquiring whether you have to have a body corporate. That's what my issue is.
No, don't complicate it.
Right, just leave it as it is.
Sounds like you're onto a good thing there, Ishmael. Rather leave it. If it's safe, it's not broken, don't fix it.
No, we have an understanding, we fix it.
Well, that sounds great. It sounds
We have a fantastic understanding. Nobody has any complaints about that.
Well, I wish more of us could live like that, Ishmael. You seem to have got it right.
We've got it right. We don't. It's only when the time comes when the time is painting, because somebody wants to paint it a different color. We have no even issue about that. We told them you can paint whatever color you want to. We're not keeping it standard.
Well, you sound like you've got the ideal situation there, Ishmael.
We don't have a problem.
Good luck. That sounds fabulous. Thanks for
Thank you
getting
so
through.
much. Thank you.
Good night to you.
Good night.
Good night. You're listening to SAFM, South Africa's news and information leader. I'm Karen Key, and this is the Law Report. My guest tonight is Phil Kolothi. He's owner and managing director of Land and Sea Development Services, and he's a specialist in the corporate management of sectional title schemes and private estates. If you have any questions, you can call us on 0892 10 2010. 0892 10 2010. AB in Ladysmith, KZN. Good evening. I believe you know Ishmael, but you've got a different question to his. How are you?
Hi, good evening. Yes. Okay, I'm inquiring about a developer. Who say about 10, 12 years ago started a development, and now that company has gone into voluntary liquidation. But there has been a notarial bond of cession, to extend the scheme. So what I'd like to find out, in terms, I think there's a schedule in terms of Section 11, where I think the original developer had, or his successor in title, had a right to, extend the scheme, over 50 years. Now, say if 80% of the original land has been, developed, and they say 20% of that land is still, left, where there's incomplete units. Can that, land and that, a new extended development be alienated from the existing body corporate, which is actually, as you mentioned earlier, is in, say, deep debt?
Okay, look, is this a sectional title scheme or
yes, yeah.
free? So it's a sectional title scheme.
Correct, yes.
Okay, it's a tricky question. That look, I'm not an attorney, but if the body corporate has come into being, I'm just thinking as I'm speaking, and you have a board of trustees, you guys can the trustees can manage the scheme. Somebody's got to take over from the developer.
No, he's saying that the original thing is in serious debt, and there's now this new section that's coming up, and he wants to know if this new section can alienate itself from the bit that's in bad debt. It's a separate section.
Yeah, in fact, the existing body corporate is under administration. From there's an administrator from the High Court, so he's handling the existing body corporate.
So, can the new bit that's now coming online, can they alienate themselves from what's already in deep trouble?
Yeah, the land it hasn't been developed now.
It hasn't been developed yet. Okay.
I'm not sure you can because that sectional title scheme will be on one earth. The only way that you could possibly do that is persuade the executive of the state or the liquidated company to maybe subdivide the property and create a new property with the good stuff on it, and establish a whole new sectional title scheme. I presume there are a couple of freestanding buildings, and it's not just one building. Is that right?
Correct. Yes. Yeah.
Okay. So if it's some buildings that are, let's call it in good nick, and you guys want to get out of the mess, you might be able to come to some sort of arrangement with the parties who are dealing with the mess, and try and subdivide the your section out and form a brand new scheme entirely.
Yes.
I wouldn't be surprised if that could be done. They're complicating things like access and things like that, but I think you could probably do that.
Would that piece, the new piece, AB, would that have its own access to it?
Yeah, I think there is a separate access to the new development. Yeah.
Have they already started developing on that new piece or not yet?
No, it's like sort of incomplete units.
Oh, it's incomplete units. Okay.
Yes.
So as Phil says, maybe you can apply to have that sort of subdivided and make that new section a whole separate thing and start a new sort of sectional title thing with that new section.
Yeah.
But you can't do it unilaterally. You're going to have to do it by agreement with whoever's dealing with the other part. Well, with the whole part at this point in time.
You mean between the administrator and the liquidator of the...
Yes.
You're going to have to come to an arrangement. You're going to have to deal with them. You can't do it unilaterally. You're not going to be able to.
Okay, thank you very much.
Okay, thanks,
Okay.
AB.
Bye-bye.
Thanks,
Good
good night to you. Well, back down in Cape Town now. Kafua, good evening.
Hi.
Hi, how can we help you?
Yes, I've got a situation, in a sectional title, there are two sections, and because there are two sections, there are only two trustees as well, so one trustee for each section. Now, part of the building is common property, right? And it is common property, but one owner occupies that, and that owner has been occupying that common property section now for the last 10 years, and that owner refuses to make a contribution toward the body corporate. So he's not paying rent or whatever for using that particular part of the building. What?
Okay, look, this sounds a bit odd because if it's a sectional title scheme, I mean, is that with two sections in it? So this is a building that's got two sections in it.
It's actually two buildings. There are two separate buildings, but part of the one building is designated as common property.
What is that common property?
Yeah,
What is he living in?
And this is a industrial complex.
Yeah, but you can't live in common property.
No.
You can't use it.
Yeah, but he is using it. It is actually a built-up area in which there is refrigeration plant. A refrigeration equipment that occupies that, but it is clearly designated as common property on the sectional plans.
Well, I don't know how on earth he's living in it. It's if this is a registered scheme, in the deeds office,
right?
He has no legal right to occupy common property.
But that is this situation. He is occupying it.
But you said he was the owner.
Okay. As I said, in the sectional title scheme, there are two separate buildings.
Okay.
Right. Now, part of the one building is designated as common property.
Okay.
Right. I mean, there's no question about it. That is in the sectional plans.
All right.
Right. It is common property. Right. But the other owner, he occupies that common property section because his refrigeration equipment is in there. Right. And I would think that the body corporate is entitled to charge rental for that. Right? Now, because we are only two, we obviously can't reach agreement. I say he's got to pay rental. He says he's not going to pay rental.
Okay. Am I understanding? He's not living in it, he's using it.
He's using it. Yes.
Okay.
Oh, right.
All right.
Okay.
It's an industrial complex, so just bear this in mind.
No, look, by all means, I mean, the trustees have a right. He can't just take exclusive use over common property without having rights to it.
But he's done that, and because we are the two owners, we are the two trustees as well, so we obviously can't agree on it.
Well, what recourse does he have, basically, is what he's trying to find out.
Yes.
Yeah, well, the only the recourse is I'm afraid you're going to have to get hold of an attorney and kick him out. Okay. You either make him pay,
right,
and you can resolve that he's going to pay X per month. You have a meeting, a formal meeting, and just decide that that he's going to pay rental for that common property.
Now, the thing is, we have these meetings. I propose that he pays the rental. He says he wants to pay R1 a month. I mean, whereas the the rental value of that particular section is somewhere between 6,000 and 8,000 rands a month.
Well, then you just boot him out.
But
He owns the property.
No, he doesn't own
No,
the
he
common
owns
property.
the other building. This is a common property.
That's right, but he has no right to that, and I'm afraid you're going to have to get an attorney involved there because if he refuses to pay what is a fair rental, you've just got to evict him and get him out of there. And the only way you're going to have to do that is you're going to have to get the legal profession involved.
Khafua?
Yes.
Next week, it's the last Monday of the month, we do property law, general property law with Marlon Chevelu. He's an attorney that deals specifically with property law.
Okay.
Give us a call next Monday evening and speak to Marlon. I'm sure he'll be able to give you some advice from the legal perspective.
Great. Thank you.
All right. Thanks for getting through. Good night to you. Off to Stellenbosch next. Annemie, good evening.
Good evening. I'm so very glad about this program tonight.
Good. Well, how can we help you?
We just had, I just heard today, we've had a meeting on the 19th of July. I live in a sectional title place very close to the university, a very pleasant place. But we have trustees that has really made draconic laws. And I really feel like moving. I can't see myself living under these laws. And I'm not a drunken student. And we have lots of students that aren't drunken. I'm retired already.
What were the laws, Annemie?
The first one was now what I feel these rules that they have made is it takes away the protection that we have under the sectional title law. For instance, the first rule amendment said the law says that we have the right to have pets, and our place is highly suited to pets with small gardens and everything. But now, there's a lady here that is the managing agent. She lives on the property, and she hates pets. So she's made a rule that says that under no circumstances shall the trustees have the authority to consider or grant any applications whatsoever as of the date of the filing of this new rule with the registrar. The law, however, is far more reasonable. The law says that we are allowed to have pets on condition that we have a written a letter from the trustees to say it is okay. And I can't go into all the detail of the thing, but I feel it is not reasonable. They also have another law that they changed. It's rule number 12 about noise and nuisance. And what worries me here is that everything is under the discretion of the trustees. In other words, no noise that is excessive in the discretion of the trustees. In other words, you are totally subjected to the discretion of the trustees. And last year we only had 4 trustees. The one was an old lady, and she would walk past my neighbor where his little girl is playing in front of his backyard, and the parent is glad that his child is playing where it is safe, and then she would say the child is a nuisance.
Okay, ma'am, look, this is... there are a couple of principles involved here. First of all, the managing agent can't make rules, and nor can the trustees make rules. The members make the rules.
Yes.
Okay, so they just can't just willy-nilly make rules. If there's a rule, there are certain conduct rules.
Yeah.
Okay, there are management rules.
Yeah.
That enforce that the Act prescribes. Okay.
Yeah.
And there might be some different management rules that were registered with the scheme.
Yeah.
Okay. So you look, and the trustees have to apply those rules. When it comes to conduct rules, there are certain conduct rules applicable to your scheme. They're either the straightforward ones that were set out by the Act, or there were some extra rules that were incorporated by the developer and registered when the scheme was registered.
Yes.
The only way the rules can change is if the members change the rules.
Now, let me tell you what happened here. These are proposed conduct rules amendments. Now, they sent out a notice of an annual general meeting, and on this annual general meeting, item number 8 was special amendments to the conduct rules. The meeting in the last couple of years is held in the middle of July, when the weather is at its worst in the winter rainfall area. I could not attend the meeting because I was sick because of the weather. And also, we live close to the university. 90% of our people are renting, and they are students or they are working for the university. So they didn't get the notice because they are not A&Rs. What is it?
They're not owners, and
yeah.
they're not there. It's holidays.
They're not here. It is holiday.
So this is almost like they sneaked it through while there was no one there.
Absolutely. There were 6 people at the annual general meeting, and we've got 77 units.
Mm.
And they've done it before. They actually gave some of our communal grounds to specific owners, and they said it is just a conduct rule amendment. In the meantime, they allowed them to move the borders.
Ma'am, can I interrupt you?
Grensverschuiving geweest. I just don't know what that is in English.
And
the people then incorporated the larger border within the walls of their gardens, and they are now selling our ground. They are selling those units at a higher price because of their larger units. But what worries me is these rules.
Annemie, just one thing quickly before you go on.
Yeah.
At this meeting, I know with any meeting like that, with AGMs, there has to be a quorum. There has to be a certain number of people present to enable them to do anything. A full? What is? I mean, 6
Okay,
people out
all
of
right.
70-something
Thank
isn't
you
enough.
for bringing this up.
Just hang on, Annemie, just hold on. I want Phil just to answer
let
that.
me come in here.
Yeah,
Look,
Phil can.
Yes?
Yeah. I want to know. They say the quorum is 15, but we've got 77 units, and there were 6 people. But then people give a proxy to the chairman to vote on their behalf.
Okay,
okay,
Phil?
ma'am. Okay, you say there's 77 units.
Yeah,
Okay.
I think so, sir.
All right.
Or
Okay.
70.
Okay. If it's over 50 units, your quorum is 20%. So 20% of the people must be there for a quorum.
Yeah.
So I don't know what 20% of 77 is. I think it's a
Right,
bit less.
work it on 70. Work it on 70. Yeah.
Okay. 20% of that is 14.
14, yeah.
Yeah.
Okay. All right. So the quorum's 14.
Yeah.
But when it comes to a special the quorum's 14.
Yes.
Okay. Now, first of all, let's just get back. The trustees can't just make their own rules.
Yes.
Okay. The only way that the rules can be changed
Yes.
is by a special resolution
Yeah.
of the body corporate.
Yeah.
And they have to, when they're going to have a special resolution,
Yes.
they've got to call a special general. Well, it can be done at an annual general meeting as well. And that's the other thing that concerned me.
Yeah.
You mentioned that these meetings are in July.
Absolutely. It always was in
Now,
April.
your financial year ends in probably end of February, does it?
Yeah.
Okay, well, there's another problem there. Your
Yes.
trustees are not complying with the Act.
They are not complying with the Act. Please, sir, tell me everywhere where they're not complying with the Act, because then I have a leg to stand
But
on.
also, I'm just getting a note here that for a special resolution, you need 75%.
I haven't got there yet.
Sorry, I'm
Okay.
jumping the gun.
Okay. Okay.
I think I need a pen. I've got a pen. I've got a
Anyway,
pen and a paper.
All right. First of all, just on a side issue, if they're going to do it in the general meeting that you normally have every year has to be held within 4 months of the end of the financial year.
Within
4
4
months
months?
by law.
Of the end of
The financial year. So by the end of June, they should have held a general meeting
Yeah.
already. Okay.
Yeah.
But they could still hold a special general meeting later on if
Yeah.
they wish.
Yeah.
But so if it was done at the normal general meeting, the general meeting was held was out of order. But that's a side issue.
Yeah. So what can I say if
Let's get
it
back
wasn't
to-
within?
No. Let's not.
All right.
Let's put that on the side, because the most
All right.
important thing here is a special resolution is required. Now, to take a special resolution,
A special resolution. Yeah.
they have to, in the notice for the special resolution,
Yeah. In the note.
they must give the reason why they want to make the special resolution.
Yeah.
They've got to specify the reason.
They did not give any
They've
reason.
got to specify it. They've got to give the. They've got to and they've got to give the effect of the special resolution on everybody.
Yeah.
So everybody can understand what the reasons for the special resolution
Yeah.
were and what effect it is going to have on them to enable them to make a decision.
Yeah.
Okay. Now, when that special and also as for a special resolution, any general meeting that incorporates a special resolution
Yeah.
requires a 30-day notice period.
Yeah. They did give us a 30-day notice.
Okay, as opposed to the normal 14 days for
Yeah.
an ordinary general meeting.
Yeah.
Okay, now at the meeting,
Yeah.
okay,
Yeah.
there's your quorum is 20%. Okay,
Yeah.
and something you must remember.
Our quorum is 20%.
Yes, now it's 20%. Now that 20% has to be calculated in 2 manners.
Yeah.
First of all, the Act states that the quorum is 20% of the votes. Now, there might be votes by show of hands, or there might be votes by a poll, which is which is voting value on participation quota. So when the quorum gets calculated, it's got to be calculated on both methods.
Okay.
The people who are present in person or by proxy,
Yeah.
you've got to have it by number and by their participation quota value.
Yeah.
All right. And that's got to be more than 20%.
All
and then,
right.
and
Now,
then,
I must be absolutely clear on this. If there were 6 people present, and the 6 people would include 2 people from the managing agent and 4
No.
Yeah.
Just hang on. Managing agent is not a member, and the managing agent cannot vote.
managing agent doesn't count.
No. Only registered owners in the sectional title scheme
Yeah.
have a right to vote. Okay.
Yeah.
Registered owners.
Yeah.
And if there's a trustee who is not an owner, he's not allowed to vote either. And you can have trustees who aren't owners.
Yeah.
Okay?
Yeah.
And at that meeting, so it's
Yeah.
got to be described very carefully what the business is about,
Yeah.
what the causes and what the effects are going to be of the special resolution. And when the vote happens,
Yeah.
you have to have a 75% majority in favor, otherwise the special resolution cannot be adopted.
Yeah. All right. You have to have a 75% majority.
Voting in favor.
Majority voting in favor.
Yes.
Now,
So when that happens, ma'am, can I just
now, can I tell you what
interrupt you?
happened last year, not this year? There were 6 people at the meeting last year as well. Then there were 11 people that gave volmacht to the chairman to vote on their behalf, and his own vote would make his votes 12. So 6 people, and then 12 paper votes, people that weren't there. But
Now, there's a procedural thing here that I'd like to look. It's up to they're a chairman and they're a chairman.
yeah,
If I was a chairman and I was given proxies,
yes,
and my proxy did not indicate what I must vote on their behalf,
yes,
I would abstain. Because just remember, the purpose of a proxy is not to vote. The purpose of a proxy is to be there in your place.
yeah,
Is to make you present at the meeting.
yeah,
And therefore, when people hand in proxies, they should indicate what they want the chairman to vote. Look, you can't stop the chairman from voting if they haven't
Yeah.
stated that. But it's in my view, it's bad faith.
Disingenuous, yeah.
It's disingenuous for a chairman
Yeah.
to just decide.
yeah.
If I was a chairman, I wouldn't vote. I'd abstain if the member didn't
But
say
now,
why.
can I ask you, the new Sectional Title Schemes Management Act, that's going
Yeah.
to restrict the number of proxies that you can have at one of these things.
That
Am I
is
correct?
100% correct. It's going to stop all of this nonsense because,
Yeah, because that is terrible nonsense.
yeah. And so, ma'am, when a meeting like that happens,
Yeah.
you need to do some work. You need to go and lobby.
I did,
under
sir, but they
under
weren't here. It was university holiday.
Yeah.
Yeah.
Yeah. Anyway, but look, it's there's things that just unfortunately you can do nothing about. I'm just giving you the facts. Must be a 75% majority, and if there's a 75% majority and the special resolution is adopted, it's adopted, ma'am, and that's it.
Anemi, it sounds like a terrible situation. I wish you all the best. Thank you very much indeed for getting through to us this evening. We have to move on. We're running out of time and we've got loads more calls to get through. I don't think we're going to make it, unfortunately. Dorothy in Cape Town, how are you? How can we help
Yes,
you?
I'm fine, thank you, Corin, and thank you for taking my call, and thank you to Peter. This is my first winter in a flat that I bought, and I noticed when I moved in that there was some efflorescence. Each room has almost a complete wall of window, but there's cement at the bottom. It's not right down to the ground. And I noticed that there was efflorescence, which is a sign that water has come in because it starts crystallizing, the wall bubbles and that sort of thing. And I knew that it meant that there'd been water, but I didn't have time to think about it. It wasn't winter. And in this bad weather last week, it started to rain in, and my floor and carpet are wet. I phoned up the managing agent, and they said straight away to me that they send in a contractor, which was marvelous. But generally speaking, is this always the case? I just thought it was a good general question. And for instance, what if I had a faulty window, or if the window wasn't built properly? Say there was a gap or something, which isn't the case. It seems, I'm not sure where. Oh, and I climbed up to my bath and I saw that there was a crack outside at that point. And when I spoke to the previous owner, I'm not sure if she should have told me. I know there's footsteps and all that. She said, last year or the year before, they fixed up a whole lot of stuff. I must speak to them. But, they're very willing to, they've accepted that it is their problem. But is that always the case if it's coming from the outside wall?
Okay, ma'am, look, this is where the problems generally come, and it's sometimes because people are not informed.
Yes.
The section, your section, is defined as it's defined on the sectional plan, and the border of your section is halfway between the wall between you and the unit next to you. It's halfway between the slab going downwards and the unit below you, and it's halfway between the roof slab and the unit above you.
Yes.
Yes. Now, so there's no gap there, which means there is no common property there.
Yes.
Now, remember, the body corporate is responsible to maintain the common property.
Yes.
Now, if there's something wrong with one of the side walls of your unit or the back wall of your unit, if it's against another unit,
no, it's not.
Well, let's take the side wall. Any wall that's adjacent to another unit, that's between you and your neighbour.
Oh, I see.
Okay.
Yes. No,
between
that's
you
not
and
the
your
problem.
neighbour. On the walls on the outside. The common property is the outside skin of the wall.
Yes.
And the tricky part comes is when if a developer either builds a building properly.
It's a very old building, but it's very good looked after and it's well built.
Yes. Now, for water to come through an external wall, it can only come through an external wall if the cavities are not clear, if the weep holes are blocked, if the wall ties are facing the wrong way and the water gets taken from the outside skin to the inside skin, and various other things like, for instance, waterproofing of windows and waterproofing. That's damp proofing around the windows and the doors and everything to make sure that they've been put in properly. And the thresholds of the sliding doors. If the waterproofing hasn't been done properly, you get problems. Now,
it's coming in where there isn't. It's coming in where there isn't on the other side of where the window is. And I'm not too sure if it's coming in where the window is because there's bubbling there too. But it originally started where there's no window on the other outside wall. Quite a Asian, but I just thought generally it would be a good question for everybody to listen to because, as you said, we don't know which is the common property and which is ours, and thank you for explaining that.
Yeah, so, this is where the managing agent comes in, a good managing agent.
I think Dorothy's very lucky.
Yeah.
Yes,
There was no quibble.
Straight away we'll send a contractor.
Coming,
I think you were fortunate. Because,
very lucky, Dorothy.
But I did say I said, I was talking to my lawyer about something else today.
Because there are latent and patent defects, and
yes, of course.
And at the end of the day, a judgment has to be made whether it's a common property problem or whether it's your problem, and there are ways and means of doing that.
Oh, well, thank you for explaining to everybody and to me. Thank you, and thank you, Corin.
Thanks,
Good
Doris.
night.
Thanks for getting through to us. Good night to you. Well, I'm afraid that's probably our last call for this evening. We've still got a whole list of people who are trying to get through to you, Phil. So unfortunately for you, I think you're going to have to come back.
That's fine.
Would you mind joining us again in the not too distant future? And we'll have to pick up this one again. Seems a lot of people would like to speak with you.
With absolute pleasure.
Well, thank you very much indeed for joining me this evening.
Thanks for inviting me, Corin.
Well, my thanks once again this evening to Phil Kalothi, owner and managing director of Land and Sea Development Services, and he's a specialist in the corporate management of sectional title schemes and private estates, and he's been my guest on tonight's edition of the Law Report programme. If you'd like to get in touch with Phil Kalothi, you can do so by calling. It's a Cape Town number, 021 300 1640, 021 300 1640, or you can email him on Phil, that's PHIL, Phil at lsds.co.za, Phil at lsds.co.za, or you can take a look at the website. It's www.lsds.co.za. The Law Report is on the air on SAFM every Monday evening between 9 and 10. And as I said, we'll be bringing Phil back again in the next couple of weeks. It seems like he's really popular. Lots of people want to speak with him. 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 Lots of people